Well, folks, this is the 196th document filed in the Colborn lawsuit. 195th one was pretty funny, I think. Well, here we go. Declaration of Lita Walker, which was Miss Walker that they were referring to in the previous document. Lita Walker, under penalty of perjury and subject, declared as follows: I am of the attorneys of defendant Netflix, and above a caption action, I have personal knowledge of the matter set forth herein. I make this declaration in support of defendant Netflix Incorporated, opposition to plaintiff's motion to order imposing sanctions and cross motion for award attorney fees. On March 12, 2020, before the parties had held a Rule 26 conference, counsel for plaintiffs Andrew Colborn improperly served on Netflix was captioned as second set of requests for production of documents, a copy of which was filed in Exhibit 1 to the declaration of April Roxty Baker. In the following weeks, I conferred repeatedly with Ms. Baker via telephone and email regarding those requests, discovery issues more broadly, as a reflection of those emails, which were earlier filed with the court. I informed Ms. Baker of Netflix's position that discovery was unnecessary and warranted to support Colborn's opposition to Netflix, and pending motion to dismiss the Second Amendment complaint. As also informed Ms. Baker, as she acknowledged that because of the lockdown measures imposed in California and elsewhere in response to the newly declared COVID-19 pandemic, conducting discovery would be difficult, if not impossible, for all the parties a practical matter. These discussions occurred while I was counsel of record for all defendants and before producer defendants, Laura Riccardi, Maura Demos, and Crow Media. Notified the court that had retained separate counsel to represent them in litigation. During the discussions, I neither stated nor implied that Netflix had or did not have the raw footage of Stephen Avery's trial in possession. At the time, Netflix employees and counsel had limited access to the company's files because of pandemic lockdown measures. Because I did not want to mislead opposing counsel regarding the discovery issue, even evidently, I did not want to make representations regarding Netflix's possession of lack of possession of raw footage until a full search could be made and I could answer the question with confidence. Once I was able to answer the question with confidence in September 2020, I told Ms. Baker that Netflix did not have, never had, the raw footage from Stephen Avery's murder trial. After the parties unsuccessfully mediation sent the email to Ms. Barker in March 2021, reiterating that, to avoid any surprise, Netflix's position in the removal of action to federal court rendered Colborn's first set of discovery requests null and void. I told Ms. Barker that Netflix would answer those discovery requests if they were properly served, but urged her to modify the request to take into account the developments in the case since it was first filed in state court. A true and correct copy of the email is attached here to Exhibit A. To the date, neither I nor other counsel Netflix have received response to the email. The court denied defendants' pending motions to dismiss on May 26, 2021, and Netflix began identifying that and collecting documents potentially relevant to the litigation within the days of that order. Ultimately, and collected approximately 20,000 documents and used search terms to reduce the set of approximately 8,000 potential relevant documents. Netflix has now been systematically reviewing those documents for weeks. Approximately 1 month after the court entered its order to deny the motions to dismiss, Colborn mailed what was captioned as third set of discovery requests to counsel for Netflix on June 16, 2021. These were actually the first set of discovery requests properly served pursuant to federal rules, coming from more than 13 months after the party's Rule 26 conference. I received those requests to my office on June 24, 2021. Netflix timely served its response and objections to those discovery requests on July 19, 2021, and again noted that position of Colborn's first set of requests were never properly served. Colborn's counsel has not contested the scope of the responses and objections. Counsel for the parties in the matter also began negotiating an agreed protective order in the case on June 2021. Kevin Vick, counsel for producer defendants, circulated counsel for the parties a proposed protective order based on the court's template. Ms. Baker did not respond until July 19th, when she emailed the red line of proposed protective order to me and Mr. Vick. A true and correct copy of the email is attached in Exhibit B. After status conference with the court on July 28th, in which the protective order was discussed, Mr. Vick circulated to counsel the parties on July 30th a copy of the court's protective order, template along with proposed stipulation that addressed the issues raised at the conference. A true and correct copy of the email is attached here to Exhibit C. On August 26, 2021, I emailed Ms. Barker, and her co-counsel, George Burnett, a draft protocol for production of electronically stored information. As I had informed Ms. Barker on August 23rd, the ESI protocol addressed the format in which the ESI would be produced, dates, numbering ESI, and other issues regarding. In response to Ms. Barker's objections, I replied that Netflix wanted the ESI protocol because discovery potentially involves documents spanning many years, and without a simple protocol, we feared that Mr. Colborn would produce the responsive documents, which include not only email but also text messages, social media content, and unusable formats, which will waste everyone's time, delay the litigation, and may necessitate involving the court. Parties held a meeting conference telephone call on December 16, 2021. Those attending included myself, Mr. Barker, Mr. Vick, James Friedman. I tried to attend, but they denied me. During the call, I informed Ms. Barker that Netflix believed having ground rules regarding production ESI would be fair to the beneficial of all parties. Also offered to provide extension of time. For Colborn replied to Netflix discovery request, which had been served on September 3rd. Provided that Ms. Barker requested an extension, I noted that the parties had, in good faith and as a matter of professional courtesy, agreed to extensions of deadlines previously in litigation. In addition, I explained Ms. Barker that drafting and discussing the ESI protocol had not delayed Netflix collection, review, and eventual production of responsive documents. I informed Ms. Barker, however, the fact that Netflix began negotiating with producers of Making a Murder in 2013, the series premiered in 2015, and Colborn filed a suit in 2018, meant the collecting, reviewing, and producing of all records responsive to Colborn's June 2021 discovery request would take some time. I told Ms. Barker that Netflix intended to make a small production, primarily consisting of licensing agreements, shortly after the meeting conference call, file productions, responsive documents on a rolling basis, with the goal of completing most of the production of mid-October. I also informed Ms. Barker that Netflix was coordinating Mr. Vick to review documents in possession of both sets of defendants to avoid duplication of efforts and the necessity for Colborn's counsel to review multiple copies of the same documents. Mr. Vick said that his law firm recently had associate resign and that, as a result, he might need a few more weeks beyond mid-October to complete the producer-defendant's production. Ms. Barker said she understood Mr. Vick's staffing situation and did not object to taking more time. Sorry. I believe, based on conversation, that Ms. Barker understood. Although Netflix production would be largely complete by mid-October, correspondence between the defendant's review in conjunction with Mr. Vick's firm might be delayed by 2 or 3 weeks. During the call, Ms. Barker did not raise or seek or resolve any other discovery issues, nor did it threaten to file any motions to compel for sanctions. Instead, Ms. Barker agreed to consult with her co-counsel about the ESI protocol and sequencing of the discovery, see an agreement could be reached. Shortly after the call ended, I sent an email to Ms. Barker summarizing the discussion and asking her to let me know if she had a different understanding. Barker's sanctions. Ms. Barker did not respond to this email, despite the request for a clarification. As promised, Netflix the following day produced 7 documents totaling 135 pages. Netflix made a second production of documents on September 27th, consisting of 4 Excel spreadsheets, 60 documents. Colborn's response to Netflix's first set of discovery, served on October 6th, referenced many of these documents. Without any warning, Colborn filed a motion for order imposing sanctions on September 24th. In response, my colleague, Mr. Friedman, called Ms. Barker on September 27th and attempted to persuade her to the motion when meritless is inappropriate. Mr. Friedman asked Ms. Barker to withdraw the motion, but she refused. I wrote Ms. Barker on October 7, 2021, again pointing out the motion's lack of any basis in fact or law, and again asking for it to withdraw it. A true and correct copy of that correspondence is attached here. Netflix made another production today, October 15, 2021, consisting of 347 documents, responsive to Colborn's third set of documents request. Thus, it believes it has now produced the bulk of non-privileged documents in possession that are responsive to those requests. Setting aside correspondence among defendants that I told Ms. Barker was being reviewed in coordination with Mr. Vick's firm. In addition, Netflix is investigating whether potentially relevant documents may be stored in various third-party platforms such as Pix, Vimeo. Reference to the documents counsel recently reviewed the produced. Netflix anticipates that any remaining response non-privileged documents will be produced within the next few weeks. I declare under penalty of perjury that the foregoing is true and correct. So, yeah. I don't know why this document came out after the other one, because they go into way more detail on the other one. But as soon as something else comes out again, I'll notify you. Again, this is there's 196 documents now, so yeah. And they're now asking for reimbursement for all they've been put through. And they said if they do go through and catalog everything going back to 2013, it's going to cost them 10 grand. So I think Colborn bit off more than he can chew. Y'all have a good night.